Okay, welcome to this presentation. We're going to be covering Chapter 16, the Tort Reform chapter that is part of the tort class. So let me go ahead and go to that section of the course materials. So I'm down in Chapter 16, and I'm going to open up Chapter 16's PowerPoint. We're going to look at the PowerPoint, spend some time with that, and then spend some time with a variety of articles on the topic of tort reform. This is one of the chapters in the course that we actually do talk about how Texas approaches a particular issue. So let's begin. I guess the first thing when we talk about tort reform is to get a good handle on what reformers in this area are concerned about. What's on their minds? What are their priorities? What is their worldview? What is their understanding of the facts? And we'll also look at the perspective and point of view of individuals who oppose tort reform, because we'll see tort reform is a very controversial topic. People have a variety of opinions on the topic, and honestly, if you talk to people on the two sides, you'll feel almost as if you're hearing about two different worldviews. It seems that not only do people have a different take on the issue, many times they also have a different understanding of the facts of the situation. So it's good to ask good questions as you read articles. Think to yourself what the support for this particular claim is. You may want to confirm that the information you're reading is accurate before you reach a decision about where you might come down on a particular issue. So I guess one of the first things that we think about when we think about tort law, and we've already kind of explored this issue a little bit in this course, but this is a good time to revisit the issue, is why do we have tort law? What are we trying to do when we talk about tort law? And here are a list of 5 things that are often raised as goals of tort law. And some of these, most of us, I think, would agree with and say, yes, that's a good reason. Some of these, though, some of us might say, maybe that isn't a good idea to have in your tort system. These aren't provable facts. These aren't things that we can go back and say, well, once we do enough research, we're going to know what the answer to this question is, because it has to do with opinion and values and priorities. And so these aren't provable issues, although certainly data and statistics can be very helpful in reaching a decision about what our policy as a state and as a nation ought to be in this area. So let's look at 5 possible goals of tort reform. One is compensation. Obviously, this would be compensation that would go towards the plaintiff who has proven his or her case. This may help the plaintiff rebound from a difficult situation. It may get money into the economy in a way that is helpful overall to the economy, but it's also more specifically helpful for the economy in that many times victims of torts have a physical injury, and the injury may be of the type that we as a society pay for. For example, if I'm in a car accident and I'm taken to the emergency room, let's say I don't have any insurance. Well, we're not going to let that person die in the emergency room. We're going to perform whatever medical procedures need to be performed on that person. Excuse me. And so we as a society will be paying for that. If a victim were to ultimately sue whomever caused the accident, then we, the taxpayers, we, the people who paid for some of the expenses that the victim suffered, would also be in line to receive compensation. So that's where compensation fits into the equation. This is a relatively uncontroversial part of the equation. But even here, there are some controversy. For example, what are we compensating? Are we going to compensate a victim just for the medical bills or just for the time off work that he or she had? Or are we also going to compensate the victim for the mental anguish, the pain and suffering that he or she may have experienced? And that's a more complicated issue for a few reasons. First of all, compensating for that is inherently a subjective evaluation. None of us can feel the pain of somebody else, And so the only way that we are going to be able to really understand it is to have a good understanding as to the severity and type of injuries that the victim experienced, and the explanation about this particular victim's experience of the pain. But at the end of the day, it's going to be very hard for the jury to really have a deep understanding of how much pain and suffering there might have been involved in the situation. The second problem with compensating for pain and suffering is that it opens up the possibility of exaggeration or even perjury. The plaintiff has an incentive to exaggerate or make a greater emphasis upon the pain than maybe he or she is actually feeling. And it's very difficult to disprove that type of thing. I mean, after all, no one knows the pain that another person experiences. Another reason that some people are concerned about pain and suffering compensation is that it's very difficult, even if we really did have the ability to know what another person's pain experience was like. It would be it's very difficult to translate pain into a dollar sum, dollars and cents. It's not something that really lends itself too easily to that. Now, on the other side, people would say, well, but it's a real injury. I mean, in some senses, sometimes pain and suffering is the biggest part of the injury. And so not to compensate for that is going to leave the victim in a dramatically worse situation than he or she was in before. And after all, this person's the victim. So we don't want to put this person in a less advantageous position because of an incident that wasn't his or her fault. So that's one category, some examples of the concerns that folks have about the topic of compensation. Let's consider the issue of deterrence. Some people think that we ought to use the tort law system as a way to deter torts from being committed. This applies with both intentional torts and negligent torts, and even strict liability torts. A person who commits an intentional tort obviously is most directly affected by this. If he knows that he may have to pay significant damages, that may make him less likely to commit the tort. But even with negligence and strict liability, a person who acts negligently may think twice about his or her behavior, may drive within the speed limit, or may drive without turning on or talking on the phone, or doing other activities that could be a source of distraction. If that person realizes that they might experience a significant financial cost if there were an accident. And the same would apply in a strict liability situation. That drug manufacturer might run extra tests, even though he's not negligent. If he were to release the product now, he might want to be super, super careful to avoid having to pay out any kinds of verdicts to plaintiffs in that particular situation. So deterrence, some people see as a good function of tort reform, or of the tort law, but other people, tort reformers usually, take a different tack and say, well, look, we already have a criminal justice system. That's our society's answer to deterrence. It's the way that we motivate people not to do things. And so maybe we shouldn't be including that in our tort system. Let's look at the next one. This is cost spreading. When a victim is subject to a tort, typically the victim, and possibly the larger community if the victim can't pay his medical bills, but certainly the main focus is on the victim, has oftentimes experiences a dramatic and very large cost, medical bills, other types of bills. And it's borne by one person, and that person didn't usually choose to be the victim, and oftentimes that person did not contribute to that person being a victim. And so the idea of spreading that major cost over many people may be a valid response. We certainly already do that with insurance. And so that could be a issue or a way of looking at that. Then let's look at restoration. Restoration and compensation are excuse me. are very similar. What we're doing here is restoring the victim to the position that he or she was in before. But again, what do we mean by restoration? If a victim has had, say, an amputation as a result of his injury, there's really no way to restore that victim. So we're going to have to use money to get that victim excuse me, back to the position that he or she was in before. But money doesn't really restore the person. And so sometimes the goal of restoration is only imperfectly met, if at all, through our tort system. And tort reformers might say, well, we're overreaching by expecting tort law to try to restore all types of injuries to plaintiffs. And then a fifth goal for some folks of the tort system is the opportunity to expose things like corruption, incompetence, or other types of misconduct. It could be that a corporation doesn't have appropriate checks and balances in place, and yet that those failures may have only come to light as a result of a lawsuit. And this now allows the public to know about those issues, or possibly government agencies to know about those issues. So there can be that aspect of tort issues. So again, you may come down and think all of these are appropriate or only some of these are appropriate. And you may even have other ideas about what's appropriate. But these are the things that we think about when we look at tort reform. Your answers to these questions in many cases will influence how you feel about tort reform, whether you think it's a good idea or a bad idea. Even if you agree, if you had two people and we both agree about the goals, many times people will say, well, we agree about the goals, but we disagree about whether our current system is meeting those goals. So there can be a philosophical agreement, but a feeling that as a practical matter, we've come down on different sides in terms of whether our system is effective or not. A little bit of history about tort reform. The first tort reformers had a different political ideology than current tort reformers did. Initially, the thought was that plaintiffs were not treated adequately by the tort system that we had. And in fact, in the early 1900s, tort reformers were trying to figure out mechanisms to get more money into the hands of plaintiffs. And this continued, as a perspective for a while. But then we saw in the 60s and 70s and 80s a significant increase to medical costs. And obviously when medical costs rose, for whatever reason it did, and that's a matter of a fair amount of controversy, but whatever reason caused it to rise, it certainly did rise. That's not in dispute. Well, that caused health insurance to rise, and that, of course, affects all of us. Those of us who consume health insurance, those of us who are shareholders in corporations that provide health insurance to their employees, those of us who are taxpayers who, through our tax dollars, support Medicaid and Medicare and federal employees' health insurance program. So we all have a role in that health insurance situation, or the rise of health insurance, and certainly that was a concern and continues to be a concern of policymakers. So with this change in kind of the costs of health insurance, people started thinking, well, what can we do to get these under control? And certainly there's been many different ideas been advanced about how we might solve this problem, or at least solve parts of the problem. And one of the ideas was, well, let's, in some respect, reduce the number of lawsuits or reduce the size of the verdicts, and that will cause the malpractice insurance that doctors and other people in the medical field carry, and then that will mean that the doctors are able to charge less, and then that will mean our health insurance premiums go down. That was the idea. And so that, with that thought process in their minds, here were some things that the tort reformers thought we needed to address. One was their feeling that the law had really flip-flopped. Maybe back in the 1800s, tort law was defense-oriented, but certainly after the progressive reformers, it became plaintiff-oriented. At least this is the opinion of the tort reformers of today. And the examples that they pointed to show that this had happened was the expansion of that strict liability theory. We've always had negligence, and we've always had intentional torts. And there's always been a little bit of strict liability out there, but the idea that it has grown significantly is pretty indisputable. Now, whether that's a good thing or a bad thing, people may differ on, but folks who think it's not a good thing would point to that as a reason that we might need tort reform. Another issue is about causation requirements, showing that link between the harm and the action, the tort, the breach of duty, and the harm or the damages that resulted. In some cases, that proximate cause requirement has been relaxed. Plaintiffs always also point to the comparative negligence, the development of that theory in the 70s and 80s. You may recall prior to the Lee versus Yellow Cab case, and then all the other cases that came after it, and all the statutes that came after it, we were in a contributory negligence world. And in that world, in order for a plaintiff to prevail, he or she could not be even 1% liable for the harm that he or she experienced. And so the development of comparative negligence was definitely a big win for the plaintiff's bar. And then we also had the fact that privity was no longer required, at least not routinely required, for many products liability cases. So you, the injured party, didn't have to be the one who had bought the item in order to be able to recover. So those are some examples of how tort law had shifted over time. Maybe it's a good shift, maybe it's a bad shift, but had clearly shifted over time so that the plaintiffs found it easier to be successful. Another concern of some tort reformers is litigiousness. The concern that there's more litigation out today in the United States than there have been in the past, and some feel there's more litigation in the United States compared to other countries. And these reformers many times feel that this is a negative fact, that it points to negative things about our culture, maybe the lack of personal responsibility, the lack of civility, lots of different ideas out there. But again, this is being perceived in a negative light. Also, reformers are concerned about what are oftentimes called a runaway verdict, when defendants are being poured out, being forced to pay large jury verdicts, even when the degree of liability may not be especially strong, or the damages that appear to be in existence don't appear to be especially large. Sometimes tort reformers look upon these verdicts as kind of the jury being like Santa Claus. They're able to essentially give free money to nice plaintiffs, because after all, it's a big corporation. It doesn't really matter whether the corporation, a million here, a million there, doesn't make a difference to the corporation. Of course, in the aggregate, if all juries felt that way, then it would make a huge impact upon the larger economy. Now, other people who oppose tort reform say that while there have been runaway verdicts, they are not very common, and they are not sufficiently numerous or sufficiently large that they are affecting the overall economy, the overall insurance rates that people experience. So again, we said before how sometimes the differences in this area aren't theoretical differences, but are more the evidentiary differences. Another thing that tort reformers today point to is the inhibition of medical practice and business, that some doctors are declining to practice in certain areas because of concerns about litigation, both geographic areas and areas of specialty. Some doctors are, or at least the perception is, are practicing something called defensive medicine. They may think in their best judgment that this patient doesn't need this test or doesn't need this procedure, and yet they feel that they need to protect themselves by ordering that procedure, ordering that test. And these actions can cause the patient unnecessary concerns, unnecessary pain, unnecessary expense, and it can also drive up the cost of our medical system overall. So those are some things that are on the minds of people considering tort reform. And again, here is a little bit more specifics about a couple of these. Well, there's pretty much already covered these topics. The textbook does make a few comments about litigiousness. It says that American litigation rates are not significantly higher than other Western countries, so it's making an evidentiary claim. It is also saying, and this one is, I don't have independent knowledge one way or the other whether this is a true statement, but this statement sounds right. That most or the vast majority of litigation is in state courts. There's relatively little of these types of cases in federal courts. And the few times where they do get into federal courts, the court is usually sitting in diversity and is applying state law and not some kind of federal law. And of course, the vast majority of cases filed naturally are small claims cases, not involving large sums of money. Then here's another statistic that the textbook advances. Again, I don't have any knowledge one way or the other about this, but they say that plaintiffs win only about 48% of the time. Now, I will tell you that, and I'll assume for the sake of argument that this is a good statistic. That may be true, but there's the perception at least that there are certain parts of the country or certain communities where that number is dramatically higher, and there's probably other parts of the communities where that number is dramatically lower. So that's, where your car accident happens, strangely enough, can affect whether you're going to get a big verdict or not. So again, the tort law system that we had prior to this last round of tort reform, concerns were that the prices for legal services were going up, that unnecessary tests and procedures were being done, and that these were having a negative impact upon the health of our citizenry and the well-being of our community. So as you consider these issues, you may want to think about and be critical about have Americans become too litigious? What does it mean to become too litigious? Maybe other communities aren't litigious enough, or maybe there's lots of different ways of looking at this and evaluating the data. I encourage you to look at it carefully and reach your own conclusion. You may well conclude that we're too litigious. You may also conclude that we're not. Another, again, criticism is that jury awards are out of control. Again, look at the data. See what you reach in terms of a conclusion. I have a few articles that I have included in the module. Some of those articles will help, but there's really not an exhaustive examination of this issue. If you have an intellectual interest in this, you'd want to dig deeper to find out more information. And you want to read people on both sides of the aisle. You want to read people who you are inclined to agree with, as well as people whom you are inclined not to agree with, to get the full picture. And then finally, the increase in tort liability has hampered business and medical communities. And again, of course, there's going to be an issue about what does it mean to hamper it. Maybe they've improved it. Maybe, yes, they've changed it, but changed it for the better. So again, there's all kinds of issues here about what changes have happened. Have the changes been positive or negative? So here's some examples of reforms that have happened, not necessarily all in Texas, although many of these have happened in Texas. But instead, we're going to talk about kind of globally, and then we'll have a separate section of this videotape that we will talk about the changes that have happened in Texas. One change is reducing the number of years for statutes of repose. You may recall a statute of repose is a statute that cuts off any liability after not so many years after an item has been manufactured. So let's say I buy item X in 2010, but the statute of repose for this particular item is 10 years. So when 2020 comes around and I have the anniversary of the date that I purchased this item, let's say the day after that, the item fails in some way and causes an injury to me. And I immediately file a lawsuit. Well, the statute of limitations is clearly not expired, but the statute of repose would mean that I waited too long to sue, even though obviously I did as promptly as I could. But the idea is, well, after 10 years, it's probably not too reasonable to expect that that item is going to be reliable, or at least that's the argument that tort reformers would make. Also, rules of discovery. When we're using this term, we're not talking about discovery rules in the sense of how many depositions you can take or how many interrogatories you can take, although those can be issues as well. But another category comes up here, and that is the discovery rule. When you have a claim against, or when you have a tort happen to you, most of the time you're in a car accident. Well, it's pretty obvious you're in a car accident. Or you have a surgical procedure and you clearly have a bad outcome afterwards. But sometimes things can happen which you don't actually find out about the tort until months or years later. And sometimes in those situations, your statutory period doesn't start to tick-tock until you discover, in other words, the tort, or you should have reasonably found out at that time because you had enough information, even if you do not actually connect the dots. So those are some issues about discovery, both the discovery process in the lawsuit as well as the rule of discovery. Then we also have alternative dispute resolution. Sometimes tort reformers are interested in having more cases settled before they get in front of the jury. And there's many ways to encourage the parties to settle. Parties can't be forced to settle, but they can be encouraged. And we'll actually talk about a couple of these mechanisms in the Texas slides. Workers' compensation immunity. This is an issue that has come up in Texas. We're not really going to talk about it here, but Texas and Oklahoma are the only two states that have gone, quote unquote, bare, that's the phrase that is used, so that employers no longer have to cover workers' compensation insurance. And so if a tort happens, if one of their employees has an injury and wants to sue, those employees will not be using a workers' compensation statute. They will be relying upon tort law. It may happen in those cases that employee will get more money as a result of not having to use the workers' compensation statute in the state, or they may find that they will receive less money or perhaps no money at all because of some kind of affirmative defense or something along those lines. Periodic payments is another way of addressing a tort reform. Instead of having lump sum payments when the plaintiff receives payments over several years, it can be an easier kind of pill for the defendant to swallow, and can be a way of managing that cost factor and also helping the defendant cover or handle the cash flow implications of that. Sovereign immunity is a concept that we've had for hundreds and hundreds of years. The idea that the king or the queen can't be sued is longstanding in the common law. But for the most part, the sovereign immunity has been taken away, or not taken away, but given away by the government. So the government has given its citizens and others the authority to sue it when the individual feels that they have a valid lawsuit against the government. But even with that surrender of sovereign immunity, states and the federal government do have the opportunity to put limitations, have shorter statutory periods, have require things like demand letters, have caps on damages and other types of remedies. And so there has been movement in this area in some jurisdictions to address sovereign immunity by making it more challenging for a plaintiff to successfully sue a government entity on a tort-like theory. And then we have limitations on attorney's fees. There's lots of different ways this can happen. It can have to do with switching to an hourly fee structure, or having a cap on the contingency fee arrangement, or affecting the way that the attorney can be paid. This can especially have important implications in class actions, which is an area certainly of tort law reform as well. Let's see here. We've already talked about a lot of these, but there's a couple that I'll touch that we haven't talked about before. Damage award caps are huge. This is probably one of the most common areas for tort reform, so that the plaintiff either has some cap that he or she cannot exceed in terms of the verdict that he or she will get, or sometimes there's certain categories of damages that are not available, or certain categories of damages that have caps. Oftentimes this is that mental anguish, pain and suffering type of damage that has a cap. And also caps to punitive damages is very common. Modification of joint and several liability. We've talked about joint and several liability a little bit. This is the part of the law that says that when one defendant is liable and the other defendant is liable, but one defendant can't pay or doesn't pay, then in some cases the plaintiff can collect the unpaid portion of the verdict by going to the deeper pocket defendant. That's what joint and several liability means. This many times people think is no longer necessary because we have comparative negligence, and so some tort reformers think that we ought to modify the joint and several liability rule, either because they think it's unfair to the defendant that isn't responsible for that particular part of the liability, or because of the feeling that there's been this shift, or in fact has been this shift to comparative negligence, so joint and several liability may make less sense. Also, there's been moves to modify the collateral source rule, and just a little refresher, you may not recall the details of the collateral source rule. We have talked about it before. We've talked about how the jury typically can't hear about Social Security disability benefits, sick pay, and vacation benefits that the plaintiff may have received. The idea is that the plaintiff ought to get the benefit of those programs instead of the defendant. But if the jury were to hear about it and were required to discount the verdict by that amount, then it's the defendant who becomes the beneficiary of those programs. But the plaintiff, in many people's thought process, should be, because the plaintiff is the one who's paid in for these insurance programs, and also the plaintiff is the one who chose this particular employer, for example, and perhaps the plaintiff forwent extra pay that another employer might have offered in exchange for getting these really excellent benefits. But again, some jurisdictions have said, no, we think the jury ought to have the information about these benefits and use that information when the jury is calculating damages. I think we've probably covered the rest of the categories. So punitive damages. Of course, the goal of punitive damages is to punish. We can see it in the word. And is also to make an example, which is that deterrent factor. If you are in a particular industry, you make widgets, and one of your competitors who makes widgets gets sued and has to pay punitive damages, and you think to yourself, wow, I do what he does, that might cause you to stop and think, maybe I need to stop doing whatever that particular item is. And the concern that some people have is that if we don't have any punitive damages, or we have a low cap on punitive damages, companies might see defective product lawsuits as just a cost of doing business, and they might be less willing to improve the product or issue a recall for that particular product. And so plaintiffs would continue to be injured. the case that some people point to for this is the Grimshaw versus Ford Motor Company case. This is that Ford Pinto topic. There are actually several Ford Pinto cases, but this is the one that gets more of the publicity. You may recall in the Ford Pinto case, the Ford Pinto, which was a relatively inexpensive car, the Ford company had elected not to put in some safety features because of expense, even though the expense would not have been significant. And as a result of the lack of safety features, it was rather easy for Ford to have its gas tank punctured and for there to be a bad fire. So obviously the people either excuse me, were badly injured or or were killed. So here are some a flip side though of people who say, well, yeah, those things might happen if we were to eliminate or lessen punitive damages. Those bad things, but bad things sometimes happen perhaps because we have punitive damages. For example, maybe some products aren't even developed because of the concern that we develop this and maybe something goes awry, we may have to pay lots and lots of damages. So it may squelch or limit innovation. It may cause people to file lawsuits who otherwise wouldn't, and might cause that litigiousness that we've talked about before. Some people think it creates a windfall for the plaintiffs. After all, they're entitled to the damages that they actually have. The punitive damages are in excess of those damages. And so the plaintiffs aren't getting just 100% of their damages. They're getting maybe 100 or 110% or 100 or 200% or 300% of their damages. And it may motivate doctors to leave certain industries. There's anecdotal evidence in certain communities that many doctors, especially in the obstetrics area, became unwilling to deliver babies in particular markets, and it caused it in some places it became difficult for a mother to locate a doctor willing to be her physician for her delivery. Okay, so let's look at a case. This is an actual U.S. Supreme Court case about punitive damages. So this doesn't have to do directly with tort reform, unless you consider the U.S. Supreme Court in tort reform. Usually when we talk about tort reform, we're talking about the legislature, so obviously the U.S. Supreme Court's not involved in that. In this case, I believe that BMW in, I want to say it was in Atlanta or Alabama, or Georgia or Alabama. Anyway, someplace in the South. I think it was Alabama. Had this particular dealership had, I think it was maybe rolled back their odometers or maybe did body repairs and didn't reveal the particular body repairs. I can't remember the specifics. But certainly the dealership did something that it shouldn't have done. But the actual, and I guess Mr. Gore in this case found out about this, is not Al Gore, the vice president, but just a random person. And Mr. Gore figured out what happened and he sued. But his damages were quite modest. I mean, if it was a rollback of the odometer, it caused the value of his car once he found out the information to be, about $4,000 less. But he also pursued punitive damages, and that jury awarded him, in addition to his $4,000 worth of actual damages, $2 million in punitive damages. So we got $2,004,000. Well, not surprisingly, BMW appealed the ruling up to the U.S. Supreme Court. And the Supreme Court said, well, yes, punitive damages are a lawful mechanism if states want to have them. But the Due Process Clause of the 14th Amendment prohibits states from imposing grossly excessive punishments on tortfeasors. And what the court focused on was the multiplier The damages were only $4,000, but the punitives were 500 times more than that, and that ratio seemed really out of whack. And so many people think a ratio of about 10 to 1 is probably close to about the limit. But we have, it's going to depend upon the circumstances. The court hasn't given a magic number. So let's look at joint and several liability. Again, this is when one defendant, when two defendants both have been found responsible for a particular tort, and where one defendant lacks the money to pay the verdict that is his portion. And so the other defendant is forced to pay not only his portion, but the other guy's portion. And so the concerns are, well, first of all, it's unfair to the deep pocket defendant. And the feeling is, well, the plaintiff ought to be the one who bears the risk of the defendant who's insolvent, not another defendant. Again, that's a values call about who ought to bear that risk. There's not a right or wrong answer to it. Joint and several liability can increase insurance costs because usually the one that is the deep pocket is the one with insurance. And so it ends up working out that insurers almost always have to pay even when the defendant who's most responsible was uninsured. And of course, the fact that insurers are always paying means that all of us who pay for insurance end up paying higher premiums. Then we already talked about comparative negligence. Many people think makes joint and several liability no longer necessary. So we are done with the Chapter 16 PowerPoint. If you have questions about it, please raise them in class. I'll be delighted to talk about it in more detail at that time. Let's go back to our module and go over some of the documents that we have in the folder. This is the first document. I'm not going to encourage you to spend a lot of time on it. This is a more recent. There was some tort reform in 2013 as well, and that there will likely be in years to come. But this kind of gives you an overview of what happened in the 2011 legislative session. As you know, in Texas, our legislature meets every other year unless it's in special session. And so this gives you an overview, but there's really nothing here that is especially memorable. I just wanted to kind of show that to you. Glance it over, but so you surely don't have to commit the items to memory or anything along those lines. And now we have the reform legislation in Texas. This is the document that I do ask that you spend some time being familiar with. You may appreciate that when it comes time to take a test because you may have some questions on this, hint, 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 and this might be the best document for you to look to. So I'm going to point out some aspects. You certainly don't have to commit this to memory. It's quite a long document, but I'm going to point out some things that I do ask that you be aware of. One is punitive damages. There is a cap on punitive damages of, we'll just talk about it being $200,000. There's actually a little bit more complicated equation in Texas. Another is that the level of proof for punitive damages is higher. It's that clear and convincing evidence standard. We've talked in the class about how we have 3 evidentiary standards in the common law. One is beyond a reasonable doubt, which applies only in criminal cases. And then we have preponderance of the evidence, which applies in the vast majority of situations in civil cases. And then we have a standard in the middle, or not in between the two, I shouldn't say in the middle, that requires more than preponderance, less than beyond a reasonable doubt. And that's clear and convincing evidence. And then finally, in order to award punitive damages, all of the jurors have to agree. There can't be a split verdict. And so you can see all 3 of these measures are going to reduce the likelihood and the amount of punitive damages in Texas. Maybe it's a good thing, maybe it's not, but that, I think everyone agree, has had that effect. we've already talked about this, so this isn't going to be new news to you. In Texas, a defendant is liable for only its percentage of fault unless it is more than 50% responsible. So this goes back to joint and several liability. Let's imagine for a second that Bob is 70% liable for whatever happened. The plaintiff is 10% liable, and Larry is 20% liable. Well, Larry doesn't have two nickels to rub together. So the plaintiff wants to get the 90%, the part that isn't his liability, from Bob. Under this change in tort law, he'll still be able to do that because the jury has found that Bob is over 50% responsible, or is more than 50% responsible. But let's change the numbers. This time Bob is 40% responsible. The plaintiff is, we'll say, still 10% responsible. And then Larry is 30% responsible. And let's see here, we'll have Susan is 20% responsible. Hopefully that adds up to 100%. Larry still doesn't have any money, so plaintiff wants to get 90% of the recovery because, of course, the jury found him responsible for 10%. He is able to get Susan's 20% from Susan and Bob's 40% from Bob, but he's looking for somebody to get Larry's 30%. And unfortunately, in this situation, given this tort reform, the plaintiff's going to be out of luck because neither Bob nor Susan is more than 50% responsible. And so the plaintiff, instead of Bob or Susan, is going to have to bear that cost of Larry's inability to pay. So again, we talked before about joint and several liability. You're really deciding, should the defendants pay or should the plaintiff pay? Okay, we're under number 5 now, and there are caps for healthcare providers, caps on damages for non-economic damages. And usually we're talking about pain and suffering in situations. And those are going to be capped at $250,000 per claimant. So that would be the most that you could get for pain and suffering in Texas. And so again, this is going back to the concerns about how do you prove pain and suffering, how do you quantify it, the concerns about people perhaps exaggerating their symptoms. Next, I previously spoke about this, is that there were some jurisdictions in Texas that were perceived to be very pro-plaintiff. One of those areas was the Valley that had that reputation. Also, big cities, those counties were perceived to be more amenable to large verdicts. So places like Dallas County, Harris County, Bexar County, Travis County, places like that were viewed in that particular way. A county like Collin or Rockwall would be perceived of as not as pro-plaintiff. And so what was happening is that plaintiff's attorneys would try to figure out a way to get their case in a county court that had a history of being very favorable for plaintiffs. And so the rules about how venue was established were tightened to make that less of an option. And then I'm going to talk about one more. And again, there's lots we could talk about, but this was something we talked about in one of our one of our chapters, and so I wanted to show what we've done in Texas. Let's imagine it's a car accident case, and the plaintiff has been severely injured. But unfortunately for the plaintiff, he or she wasn't wearing a seatbelt at the time. And very likely, if he or she had been wearing a seatbelt, then the injuries would have been less severe. Well, the jury is entitled to know about that lack of seatbelt, and that knowledge is going to affect liability. For example, if the plaintiff wasn't wearing a seatbelt, then very possibly the jury will find a higher percentage of responsibility for the accident in that particular person. And also, it could affect the calculation of damages. So those are some possible areas of tort reform that have been quite significant. I just covered 5. You'll want to know those 5. Be familiar with those 5 so that you'll be able to talk intelligently and recognize them on the test. Again, those caps on punitives and how we go about doing that in Texas, the proportionate responsibility change, the cap on non-economic damages such as pain and suffering in a medical case, the tightening of the venue rules, and the fact that seatbelt evidence is now allowed. Okay, so let's go back to our chapter again. Excuse me. Okay. Then this is a counterbalancing article. The article that I just cited, which gave a fairly detailed description of tort reform, was by a group that supports tort reform. And while they I think fairly describe the changes in the law, they certainly have an agenda with the postings. So I wanted to give a counterbalance of another article that talks about why this writer, Mr. Potter, thinks that tort reform hasn't been good for Texas. So again, this doesn't go into all of the particulars of tort reform, so I'm not recommending it for you to learn the particulars of what we've done in Texas. But this is also a sign reading so that you'll be able to respond to the arguments both pro and con for tort reform in Texas. And in that spirit, I want to point you to this item. Texas Governor Rick Perry offers support to tort reform efforts. This is a video. I'm not going to turn it on right now. It's just 2.5 minutes in which then Governor Perry talks about what he thinks tort reform has done for Texans. So he disagrees strongly with these mythical benefits of tort reform in Texas author, although obviously the governor isn't responding to this particular argument. So let me move this around. Then the last 2 articles have to do with the famous Mcdonald's hot coffee case. The first one takes the position that the plaintiff should not have received a large verdict, or perhaps any verdict at all. And the second article takes the perspective that the plaintiff it was correct for the plaintiff to receive the large verdict. So you ought to be familiar with generally the facts of the case and the reasons, both pro and con. I may ask you to argue either side, so be aware of that when you're drafting your question, or you're thinking through it, so that you'll be able to speak intelligently on either one of those perspectives. So again, if you're looking for the most important things for you to focus on, is the PowerPoint is the single most important, and then this one. Let me move it up here to the top, and I'll move this one up here to the top as well. These 2 items are the most important for you to become familiar with. This one is probably the least important. I'm going to keep it with the others because it is related to Texas tort reform. But spend a little bit of time with these and read these once or twice as well. And you'll be prepared for the test in the torts class on these topics. I hope this presentation has been helpful for you. If you have questions about the content, please don't hesitate to bring them to class, and I'll be glad to field those questions for you. Thanks for your attention. I hope you have a great day.